Hi, Attorney Steve Vonner. We're back. In this exciting episode of Litigation Warrior, we are talking about the request for production of documents. This is a critical topic in every litigation. So without further ado, let's head to the Attorney Steve litigation whiteboard. Okay, let's back this up and get busy here. Okay, this is a very important topic. Okay, when you go to court as a plaintiff, you've got to prove your case. You've got to have preponderance of the evidence in your civil case. In some cases, when you're trying to show punitive damages, you need that clear and convincing evidence, the burden of proof, okay? So let's talk a little bit about one of the discovery mechanisms that you use to try to get that physical evidence, the documentary evidence, the pictures, the things that you need to show to the jury and hold that up and say, here it is, okay? Sometimes you have to get that from the other party. One way you do that is through the request for production of documents, also called inspection of documents, okay? This is a broad discovery tool that allows you to get documents, emails, phone records, to enter property and inspect property, take pictures, to do lots of different things. So it's actually a very, very, very broad discovery tool that you need to be aware of, okay? So let's break it down for you in simple terms. You have basically a request by the propounding party. I don't know why I put that. Propounding party is going to propound the request upon the responding party, who is then going to respond. Okay, so it's a 1-2 kind of thing. They send the request. This party has an obligation to respond within the time frames. Okay, so let's talk real first, and if you don't, we'll break it down here for you. There's a meet and confer, and there could be sanctions at the end. So we'll talk about this. So the propounding party is going to serve on the responding party a request saying, I need this, I need that, I want this document, I want that contract, I want that purchase and sale agreement, I want those disclosures, I want the escrow documents, whatever the case may be. I want your software license agreement, whatever. So you're going to request your specific documents, okay? Now keep in mind, under the evidence code, you're going to have a definition section in here, by the way, in your request for production. The definition section is going to define your terms. One of the terms you're going to see is what is a writing or what is a document. And you're going to look at the evidence code. If you're litigating in California, I'm licensed in California and Arizona, so this is general legal information about these two states. But in California, you're looking at a very broad definition of what documents are, okay? Text messages, electronically stored information, phone records, memos, calendars, I mean, all kinds of things, okay? So you're going to request specific documents. Okay, now when you request specific documents, usually there's less of a chance that you're going to get an objection from the opposing party because you're being very specific. I want this document. Okay, another type of request you can make is just for categories of documents. So let's check that box. Categories of documents. So in other words, you may have a case with a lot of emails between a lot of different parties, and you may say, I want all your emails with that party from January 1st to December 31st, okay? I want all those emails. Now some of these are, that could be considered overly broad, and we'll talk about objections in a minute, but that could be considered overly broad. You could raise an objection on that. It could be some privacy issues, all kinds of things. So the more specific you can be, the better, but sometimes you need to get these categories of information, so be aware of that. Your request is also going to set forth the time, place, and manner for the document production. Okay, the turning over the documents. Now, the propounding party may say, well, I want to come to your office and I want to go through, I want the file cabinets, I want the documents that are responsive to this. You say it's in 5 file cabinets and it's too many to send me. Okay, fine, I'm going to come to your office on this day. Or you may set up so you may say, well, I'm going to be at this copy office right next to us, in between us both, and we'll meet there and we'll copy documents. Or the propounding party may say, you know, as long as you produce a legible copy to me at this address by this date, that will work for me. So the request is going to set forth your what I call your time, place, and manner. Okay. It's also going to set forth your time frames, your deadlines for responding. Okay, now usually where some people get confused, there's 2 different things here. One is the obligation of the responding party to do a written response. Written, let's just put verified. Let's put written verified response. Okay, so one of the obligations is a written verified response, which we'll jump ahead a little. Just says either I'm going to answer, I'm not going to answer, I have the document, I don't have the document, it was lost, it was destroyed, I object. It could be all these different kinds of things. Okay, that gets rid of some of those there. So, but one thing that you will set forth in your request is a time frame for this written response. Now, generally, you might be looking at 30 days. 30 days from the date that this is served on this party. Okay, they serve the document. Somebody over 18, not a party to the action, serving the document on that party, and usually 30 days. Now, if you're mailing this in state in California, add another 5. If it's out of state, so have that removed. If it's out of state, it could be 10 days. You got to check your rules. You got to check your rules on that. I can't help out on everything. But so say you give this party 40 days. Let's just take it a nice safe day. You give them 40 days to respond. There needs to be the written response within 40 days. The other thing that will be set forth is the date for the actual production. And I put a picture here, some fancy documents, some pictures of documents, contracts, those kinds of things, licensing agreements. So you have 2 dates that are going to be in here, the date to respond and the date to produce, okay? So follow me here. The date A, the date to respond with your written verifications and your response, and B, the actual production, okay? So that's what you're going to have in your request. That's a simple breakdown of that. The sending party is going to keep the originals and serve the copies. Now, bear in mind that the propounding party is not limited to one discovery request. They can go and get their information, and they can come back again, a couple months later, following a deposition. They may say, well, we have more documents we need. Set 2, set 3. Okay, so you can have different sets of these documents. So don't think you have to get it all in one document request. Get what you can, be thorough. Make sure you're going for the documents you believe are relevant to proving. Remember, when you get to trial, hearing, summary judgment, you're going to need to prove what you have, okay? Bear that in mind. A responding party, again, in response to the written request, you have a duty of due diligence, I didn't point this out, and reasonable inquiry. That means when you get a request, you say, I need that contract that you signed with Joe Schmo. You can't just go, no, I don't have it. I don't have it. I don't know who has it. Don't know. That's not enough. That's not enough under the code. You have a duty of reasonable inquiry and due diligence. Do something. Call somebody. Call the escrow company. Do you have this document? Do you have these disclosures? Call the buyer, the seller, if you're in a real estate transaction. Those kinds of things. So you're going to have a duty of reasonable diligence. Your responses here are basically going to say, yes, we accept this in whole. We will produce the documents. Don't worry. By the date, again, we will produce the documents by the date set forth in your request. We will produce. You following me here? Okay, so you produce those, or you're going to say, I'm going to give you this, but I don't have that. We can't respond to this because I lost it. I can't get you this because it burnt in a fire. I can't get you this because we only keep records for 3 years pursuant to our statutory code requirements, so I don't have it. So you're going to put your objections. Some other objections that are common, California Evidence Code Section 912. Section 912 of the California Evidence Code sets forth some other objections that may arise in your case. They may apply. For example, this party is seeking attorney-client privileged documents, or they're asking for communications between a husband and wife. Okay, the marital communication. Could be a domestic violence victim and a counselor. It could be a clergy type of privilege. Okay, so there's lots of different privileges that you can look into. More information, check out our website, Litigation Warrior, and you can Google the production for documents. Okay, so you're going to raise your objections if you have them. You're going to raise objections such as vague and ambiguous. If you don't know what they're asking for, how can you respond? So it's a valid objection, vague and ambiguous. It's also unduly burdensome. They want you to produce the whole file cabinet, okay? You know, the whole floor, all your documents from 1965 to the present. Okay, that's crazy. Okay, let's say you're an escrow company. That's crazy. How am I going to do that? So an objection would be unduly burdensome. Relevance is another one. You know, send me all the pictures of your wife when she was a swimsuit model or something. It's like, what does that have to do with this contract case over here? Unduly burdensome, not relevant, you know, those kinds of things. So check out your Evidence Code 912 objections, your vague and ambiguous objections, burdensome objections, other objections that may apply, and realize there's no duty to create. There's no duty to create evidence documents. You don't have to go. You'll say, well, let me put that together real quick. You know, you don't have to do that. There's no duty to create evidence. And materials that are produced in anticipation of litigation by your counsel, those would be work product protected type of documents, okay? Finally, if you're not going to disclose, if you're going to object and you say, I don't have it, I don't do this, or I'm not going to give it to you because of a privilege, I feel like I'm privileged, you know, those kinds of things, there's a privilege that applies, you still should disclose the identity of the document and set forth your specific grounds as to why you're not going to produce. So don't forget that little step. Identify that you say you object, identify the document and the specific grounds why you're not going to produce. Maybe you have a privilege log where you say this is on my log. I'm not going to produce this. This is attorney-client, or this is a document I had with my clergy. It's privileged, those kinds of things. So that is the responding party's duty to give a written verified means under oath. Okay, so you're going to sign it under oath, under the laws of the penalty of perjury. You're going to get that back. Then you have fulfilled step 1, which is your written response requirement. And then your step 2 is, of course, your production of documents requirement. Okay, so you got this twofold thing going on here. So you've got your written objection. We'll check that off. You produce your documents. Now, when you produce your documents, you want to state either that they're kept in the ordinary course of business. In other words, somebody may give you a stack of documents and say, here you go, this is kept in the ordinary course of business, have fun, you sort through them, have a good time. They're kept in the ordinary course of business. So that's a more difficult concept. It's something that is permissible, but it's also something that could raise objections. You may have to come and do a meet and confer with that party that's doing the document dump, just dumping a big set of documents on your plate. So keep in mind the meet and confer. But you certify that they're kept in the ordinary course of business, or you simply respond to question by question by question. Here's your response to request number 3. Here's your response to request number 8. Here's the contract you requested in number 12. So you can go forward and do that kind of thing. So you want to be helpful and cooperative. Remember, in civil cases, this is not supposed to be trial by ambush. It's not supposed to be trial by ambush. You're supposed to share and exchange, and this is the discovery process. We're discovering, I see what you have, you see what I have, we make assessments, maybe we settle the case, maybe we fight on, maybe we disagree, you know, so, but it's sharing the information and going about it like that, okay? Again, if you don't get your information, the propounding party says, I am not satisfied with this, I am not satisfied with this, this is improper, you're withholding evidence, you're abusing the process. They need to engage in the meet and confer process, which is pretty simple basically. It's either somebody sends you an email or somebody sends you a letter. If they want to be more formal, they might try to send you a letter. But they outline the various issues where they asked you for specific questions. You did not respond properly. They want their information. And if you don't give it to them, by God, they're going to court with a motion to compel and seeking sanctions. This is every attorney's secret weapon, right? So the motion, the meet and confer letter, that is, I'm meeting with you, I'm conferring, let's get this resolved without the courts. You and me, give me the document, go back and get that. Your objection's invalid. Here's some case law, here's why. But the meet and confer process is a good chance to get it resolved informally. The judges do not want to hear a lot of these ticky-tack disputes about, is this relevant, is it not? Did you really know what document? So get it worked out. Get it worked out. Get it figured out. So that's your meet and confer. If all fails, and all heck breaks loose, you've got to go to court and you file that motion to compel discovery responses. Okay, then you'll be seeking what I call the MIT sanctions. MIT sanctions. You have monetary, monetary sanctions. That's attorney fees. Give me my attorney fees that it took for me to come and get this evidence. They're wasting my time, my court's time, my client's time. I want monetary sanctions. Now, a point I'm going to say here for the in pro per plaintiffs, because you don't have an attorney, you can't get the monetary attorney fees. So that's one of the bad things about being in pro pers. You can't get those attorney fees. If the other party has an attorney, they can seek their attorney fees. But you can seek your costs and maybe some other things and see what the court will award you. So that's your M, monetary sanctions. I would be issue sanctions. That may be you didn't respond to a particular issue, so the court will find in favor of the other party on that particular issue. So if you go to trial, that issue's already been decided. So, so this could be, what I'm trying to say is it could be some harmful ramifications if you're not complying with your discovery requirements. And T, the worst of all, the death knell, terminating sanctions. Terminating, the judge can say, I'm going to dismiss the complaint. I'm going to strike the answer of the defendant. So these are can terminate your whole position. So again, this is a general overview. Now, if you don't, the final thing we have, if discovery isn't turned over, you could get at the end, I have MIL, that stands for motion in limine. I'm going to do a separate video on this. It's a separate topic. Motion in limine, that's something that gets filed before a trial, telling the court, exclude this, don't let it in, the jury doesn't get to hear it, they didn't give it to me, I asked for it, they don't get to hear this. Okay, so that's your motion in limine, and we're going to talk about that in another video. So anyway, I hope this has been helpful. This is Attorney Steve. Request for production of document. More information at litigationwarrior.com. And we hope that you have enjoyed this. Feel free to share this on your social media networks. If you need help with arbitration litigation, you need an attorney to step in, you need legal advice, give us a call. You can find us on the web at litigationwarrior.com. Attorney Steve, have a great day.